and thank you for making yourself available for consideration for appointment as a judge of the Western Cape Division of the High Court.
It is an enormous pleasure, ACJ.
Thank you. Thank you. I see that in terms of academic qualifications, Ms. Andrews, you have a BProc degree and an LLM degree.
That is correct.
That right?
That is correct, ACJ.
And you obtained both of them at the University of the Western Cape.
That is correct, ACJ.
And you obtained the BProc in 1992 and the LLM in 2013.
That is correct, ACJ.
Yes. And you served articles from 1992 April to 1994 in May.
That is correct, ACJ.
And you were admitted as an attorney in May 1994.
That is correct, ACJ.
And have you practiced as an attorney for all this time?
No, ACJ. Straight after articles, I went into a partnership. And then after that, I practiced for my own account as an attorney until I joined the magistracy in 2002 December.
Yes.
I then progressed in the ranks as a magistrate to a senior magistrate and currently a regional court magistrate.
Yes. So how many years did you practice as an attorney?
ACJ, by my calculation, I calculated to be roughly 8 years and 6 months. If you add my articles, it would be roughly 10.5 years, ACJ.
Yes. And during that time when you were practicing as an attorney, what types of cases did you handle?
ACJ, it was a variety of cases that I was that I needed to deal with. It is perhaps just to give you some contextual background. When I started as a budding attorney, I was barely 22 years old. Mm-hmm. So I entered into, in other words, I jumped into the deep end. And I was just really hoping for the best. And so when I started, we started off very small, and I was literally prepared to do anything. So it was small beginnings, dealing mostly with people who were impecunious at the time. I really have a heart for the underprivileged, and so my niche client initially were those that were in dire need. Most of those clients I would have referred for legal aid assistance. And out of those matters would emanate a huge array of matters, ranging from criminal law to civil litigation to divorces and related matters. And then slowly my practice grew. It took a bit of time, but I was very patient. It grew to extend to a broader client base, a corporate base. I eventually got the Ferreira legal contract and attended to matters that then exposed me to labor law, not much, but labor law, contracts, leases, in other words, every and any type of litigation, damages, delictual claims, intellectual property law, material work.
Did you get commercial law as well?
Sorry?
Did you have commercial law as well?
Yes. As I say, I was then fortunate at some point to work for, do matters for Maynard Mall. and that was one of my biggest client bases. And so a lot of matters that emanated from them being managing agents of tenants and those types of disputes did cross my threshold. And so it was something that I grabbed hold of almost everything that came my way, because it was literally survival. You must understand that being not only a young female practitioner, but also a Black practitioner those years back, I was feeding off what I termed the scraps, because most of the larger clients were going to the bigger firms. But I had the tenacity and endurance until I was called, I believe, to the magistracy in 2002, ACJ.
So you have been working as a magistrate since 2002, is that correct?
That is correct,
You
ACJ.
simply have been at different levels of
I have at different levels, that is correct.
Now, how many of those years did you spend in the district court?
Up until 2013, ACJ, I was in the district court. I was elevated to a senior position in an acting position around about 2011, and then a permanent senior position in 2013, and then on the regional court level intermittently, and then ever since 2016.
Now, when as a district court magistrate, did your work include adjudicating civil cases?
Initially, ACJ, I was tasked with criminal work, and when the need arose, I availed myself, but I never removed myself from doing civil work. I was always willing to assist until just prior to my acting appointment, I became more and more invested in the civil work, and then I did a lot more civil cases. And when I was elevated to the senior position at Wynberg Court in an acting position, I was in charge of the private law section. And so I was then immersed completely into civil work from then on going forward.
When would you say that was when you started being involved in civil work quite a lot, just as you say?
I would say any time from around 2010, 2011, then of course actively in 2013 upward. But as I say, intermittently, ACJ, prior to that, I was also doing matters as and when the need arose. So I was never really out of it. But when I was completely immersed, would have been roughly at about 2010, 2011 going forward.
Yes, and in terms of civil cases, are you able to share with the commissioners what branches of law in civil work you encountered in adjudicating civil matters in the magistrates' court?
I can perhaps give you an overview of where I'm currently at, and maybe work backward from there, because at the moment, if you will allow me, ACJ.
Yeah, that is okay.
Thank you. I'm currently the coordinator of the civil component at the court that I serve at. So that entails that I not only manage the courts, but I run those courts effectively. And so every person in that division is allocated duties on the trial role, on the default judgment, motion court role, and the divorce role. And those roles will deal with a number of civil matters, opposed, unopposed civil applications, default judgments that would deal with bank-related foreclosures and contractual disputes and the like. In the divorce court unopposed divorce matters. Your Rule 58 in the regional court, but Rule 43 is in the High Court. All of those applications. So ACJ, I would say everything and anything that is civil related. It also bears mentioning, if I may, that in the court that I serve, we also have quite a number of matters that are of a serious nature and of a high standard, I would submit humbly, because often we would have senior counsel being briefed in matters because of the complexities of concepts that we have to deal with. So yes, and in addition to that, pre-trial matters, there's a whole range, ACJ, unlawful arrest and detentions, it's too many to name, but I can, with a certain amount of assurance, say that I'm comfortable to deal with whatever matter I'm given and tasked to do.
And you have acted in the High Court. How many weeks or months altogether have you spent acting in the High Court?
I had an enormous privilege of being invited to act on the Western Cape High Court bench. And initially, by my calculation, I think it was the first term was for 8 weeks, the second term was for 10 weeks, my third term was a 9-week stint, and the last one was 11 weeks. By my calculation, it would total roughly about 38 weeks, and then I returned to do partly heard matters, and altogether it would probably give me another week. So maybe 39 weeks in total, ACJ.
And have you done civil trials and criminal trials in the High Court?
Yes, I did. ACJ.
And the motion court?
Yes, I did.
And how did you find motion court in the High Court?
ACJ, when I stepped into that position as an acting judge, I embraced every challenge that was thrown at me. Yes, it was daunting, but preparedness is the key to, I believe, success. So I think that I was quite prepared because I think I had conditioned my mind before the time that it would be a lot of work. I spent a lot of hours in preparing so that I could be equipped to do and call the role. I did additional research, especially in matters where I wasn't perhaps au fait or comfortable. Maybe it was matters that we don't deal with on a regional court level. But I can say with a certain amount of assurance that I think I was able to handle it, and where I did not, where I wasn't comfortable, I would reach out to colleagues and ask them to kindly just check whether I was on the right track. But I wouldn't go to them to give me the answers. I would say, this is how I see it. Is it right? And all I can say is, ACJ, that I enjoyed every moment of it. I invested myself into it. I sacrificed because I knew that when I stepped into that role, I wanted to do it with excellence. And I believe that I tried my best to do so, ACJ.
Thank you. I will now hand over to the Judge President to put questions to you. Judge President.
Thank you very much, Chairperson. Mrs. Andrews, let's go straight to the point. You acted in the Western Cape, but left under a huge cloud. And for the benefit of this commission, I will explain. I allocated you a matter involving the Democratic Alliance and the ANC. I had no idea that the leader of the Democratic Alliance in Beaufort West and the Central Karoo is in fact your cousin. You did not return the file to me. You sat in the matter and ruled in favor of the DA. I took an unprecedented step to write to the Minister of Justice and urged him to cancel your appointment. Would you like to explain yourself why you sat in a matter where your cousin is a high-ranking politician of the DA in the Western Cape and ruled in favor of the DA thereafter?
Thank you for the question, JP. I would like to say the following in response to that. First of all, when the matter was allocated to myself, it was allocated after I had returned a previous file to you, JP, because of a conflict of interest. When the matter was given, when I received that matter, the matter had litigants by name and not by party. I think if my memory serves, it was, there were 5 applicants by name, and then there were 8 respondents, the last of which was the Beaufort West municipality. This matter concerned an administrative action where the applicants in the matter had applied to set aside some irregularities. To the best of my recollection, it had to do with the appointment and unseating of the executive. The executive, as I can recall, consisted of the mayor and the mayor, the deputy mayor, and the speaker was.
I'm sorry, Ms. Andrews,
Yes.
I'm interrupting you. Please try and give brief answers.
I will.
The question is a simple one. Why
Yes.
did you sit in a matter involving the DA when you knew that your cousin was a high-ranking DA official? That's the question.
Thank you. First of all, ACJ, maybe just to cut to the point, is first, I did not know that this matter had any relevance or bearing to my cousin. I'll tell you why I say this is because he was not.
No. The question is, you would have known this matter is about, it has been brought by the DA, isn't it?
No, I did not, ACJ. I did
okay.
not. So that is the point I'm making. No, I
Okay.
did not. That is why I'm saying. The
Okay.
parties were named in the individual capacities. It wasn't overtly, in my view, a politically weighted matter. For me, I took
But from the papers, was it not
it was
clear
not
that it
clear.
was-
No, it wasn't clear. Maybe it was my naivety, I'll call it that, because I adjudicated the matter on the strength of the papers that were before me. So what happened was that there was this unseating, and there was a plethora of irregularities that emanated from the processes leading up to that. And all that they wanted was for the status quo to return. I'm aware that every step, that I'm aware that they had taken internal steps, but they did not. So the point.
Okay, hang on, Ms.
Yes.
Andrews. I'm sorry if I'm interrupting you.
Yes,
I just want to make sure that we use the time
certainly.
optimally.
Yes.
Is your answer to the Judge President that you sat in the matter because you were not aware that it involved the DA? Is that what you are saying?
Yes, I was not aware, and then I think it is important for me to say the following. I am estranged from my cousin and was not following his political career at all. I have no relationship with him, and I do believe that I did bring an impartial mind to bear on the adjudication of that matter. So I did not do that intentionally, ACJ. I certainly would not have done so had I known. And I understand that I should have recused myself. I would have done so had I known.
Did you know your cousin to be a high-ranking DA official?
ACJ, yes, I knew that he was in politics. I knew that he was aligned to the DA. But
Okay.
that doesn't necessarily mean that by implication I align myself to what he's doing.
Okay. Judge President?
Can I just follow it up, Chief Justice? And this is my last question.
Yes.
Mrs. Andrews, you must have known that he is a high-ranking member of the DA. It was all over the newspapers. He was hailed as the youngest politician in the DA, aged 29 years. You must have read that.
I don't dispute that, JP. What I'm saying, what I'd like just to reiterate that I definitely did not do it with the intention of bolstering his career or to rule in favor of him simply because he was my cousin. I adjudicated the matter on the strength of the papers, and I believe that I needed to do so because the Constitution enjoins me to do so in terms of Section 160, because there was certainly, there was no accountability and the steps were unprocedural.
But the Judge President suggests that prior to you hearing the matter, his association with the DA was all over in the newspapers. Why would you not have been aware of that?
ACJ, I know that it may sound like I am disconnected, but I definitely do not particularly follow the news, and especially when it comes to him. I am not in the Western Cape, so I'm located in KZN, so I wouldn't have really looked at things like that. So I'm not entirely sure whether I was meant to follow his career, because that wasn't, he isn't part of my circle. So I understand it was perhaps with the benefit of hindsight, that I should have maybe have looked at it through a different lens. I might have had to, I did probably lack discernment, but that wasn't how I viewed it at the time. And I did apologize to the JP for my error, and I didn't at all, it was never my intention to do that. I think in my zeal, I may have just been overzealous, but certainly it wasn't my intention to be biased in any way at all. I understand the standards that is expected of me and when to recuse.
I'm now going to give, Judge President, you are done? Yes, thank you very much. Thank you. I'm going to give the opportunity to the Premier's delegate, Ms. Stewart. If you have got any questions for the candidate, this is your opportunity.
Thank you, Acting Chief Justice. Can you hear me?
Yes, we can hear you.
Thank you. I have two questions. Just following on from Judge President's question, was your cousin mentioned in the papers at all?
Not at all.
Okay.
Not at all. Not at all. I wouldn't have known. I read the papers. Those names did not reflect his name, and it did not tell me that it was ANC versus the DA at the time. In fact, one of the persons unseated happened to be an ANC executive member. So there wasn't, in my view, it was about making sure that the status quo was returned. I was astute to inquire from the parties present, and this does not reflect what was reported, that I wanted, and I had the heart of the community as my uppermost barometer. I had engaged the parties and asked them, would this have any effect on that community? And they gave me the absolute assurance that it would not. My focus wasn't on a political, I believe maybe I'm a casualty of a political rivalry, and I just maybe didn't see it coming.
Thanks, Ms. Andrews. I do have another question for you. I noticed in the comments that were provided that both the General Counsel of the Bar and the Law Society have suggested that you are inexperienced and perhaps need some more time on the bench. I'd like to know your comment on those comments from both the council's grouping and the law society? Thank you.
Thank you for the question. I think that I believe I'm ready, although judicial education is an ongoing attribute that I think everybody should be open to do. If I can perhaps just consider the General Counsel of the Bar's comments. They do say that I need extra time, but it's important for the Commission to understand that I have produced 5 reported judgments in that very brief acting stint. I believe that I have the ability to contribute to the jurisprudence. I have the ability to develop the law. I have the passion to serve my country. And so I don't think for one moment that the comments were fair, because had that been, then perhaps some of my judgments may have been overturned, but none were up to date. So all of them remained intact regardless. I am open to correction. I think that is one of the attributes of a judge. I'm teachable and I'm willing to learn. I'm willing to grow. I'm willing to be mentored.
Thank you, Acting Chief Justice. If I can just indulge with one more question.
Yes, okay.
I note in your CV that you say your proportion of administrative and constitutional law is 5% and 5% respectively. The Western Cape government and every other organ of state spends a lot of time litigating in court in terms of administrative law. And I'd like to just ask you if you can explain to me your understanding of the difference between a review under PAJA and a review for legality, and where those two concepts derive from, how we've ended up in the space we have with respect to reviews. Thanks.
Thank you. First of all, PAJA deals with the right of everyone to an administrative action that is lawful, reasonable, and procedurally fair. Now, this is born out of the pre-1994 constitutional dispensation, where Parliament was supreme, and Parliament and the executive, its decision could not be reviewed. With the advent of with the advent of democracy, that has changed through our constitution, and more specifically, Section 175, where a court can now declare any law or conduct that is inconsistent with the Constitution to be invalid, and then make an appropriate order thereafter. In terms of a judicial review, those reviews come in different forms, and those reviews come to the courts to essentially in different ways. The first of which that comes to mind is when there was a misdirection. So a misdirection could be where, for example, the outcomes were over lenient, or perhaps it was too harsh. There would be a shockingly inappropriate outcome. The other reviews could also be based on an outcome that was not in accordance with the law. And so I have done those reviews. I understand what those sentiments entail. I understand that we can't deal with factual or interfere or lightly interfere with a decision if the lightly interfere with the factual decision unless there is a misdirection. And then there are various permutations that flow from there. So I hope that answers the question.
Thanks, Acting Chief Justice. I'm fine. I'm good.
Thank you very much. Commissioner Matolo Lepu.
Thank you, Acting Chief Justice. And good afternoon, ma'am.
Sorry, good afternoon.
Okay.
Good afternoon.
All right, I'm this side. I just wanted to find out from you in your questionnaire, because I'm looking at some of the comments made about how you packaged your submission to this commission. For instance, the LSSA that you put in everything, but most of them were not even relevant to.
May I ask you to speak up a bit?
Okay. The LSSA says you packaged your submission with documents which were not relevant to the commission. But one of the things that I saw when there's, I don't know if I'm just trying to look where they say do you belong to which organizations. You put in one of them is NADEL, and you put in one of them is Saula, but at the same time you were not a member. So I'm trying to understand why
Yes.
did you put it
I think
in?
it was, thank you, Madam Commissioner, thank you for the question. I think I just wanted full disclosure of my connection to any one of those organizations. Perhaps it was misplaced. I might have needed to put it elsewhere on my submissions, but I'm certainly not a member.
Thank you. Commissioner Schlemmer.
Thank you, ACJ. Ma'am, I would just like to ask of you, also related to your application and the voluminous nature of it, but also it's just concerning to me that you typed everything in uppercase. It's very difficult to read. I hope you don't type, well, you don't type your judgments like that.
I'm sorry, Commissioner Schlemmer. I don't know whether it's the technology or it's my ears. Can you repeat your question and try and speak up? Maybe it's my ears.
Sorry, ACJ.
Thank you.
What I said was I'm concerned with a candidate's application, apart from the voluminous nature of it, is also the fact that everything was typed in uppercase, which makes it very difficult to read. But apart from that, what I do find a concern is that it seems as if you, although you spent a lot of time, obviously, in putting it together, that you didn't read it very carefully. I mean, when it's asked whether you have any publications in law, you indicate your mini thesis or your mini dissertation as a publication, which is not considered a publication. And then when you're asked about whether some of your publications have been considered in judicial judgments, you refer to your judgments that were cited by other judgments. Can you please allay my fears that, well, I don't know whether you will be able to, because my impression is that you don't really read things carefully, and that you don't look at things with enough detail.
Thank you for the question. With the benefit of hindsight, first of all, in terms of the response and my typing in uppercase, I wasn't sure whether there was a prerequisite in terms of how the font should have been. I probably could have typed it in lowercase. I do type all my judgments, and I can assure you they're not in uppercase. Then, in terms of answering those questions, once again, with the benefit of hindsight, maybe I could have responded in a different way, but it certainly does not, it should not be a reflection on my lack of attention to detail, simply because as I say, I think I've demonstrated performance, I think, in terms of the type of matters that I can deal with and the type of judgments I can produce. Most of my judgments that I have written, if not all, have been typed by myself. And I can assure you that I do then, I am meticulous, and in fact, I pride myself in being overly pedantic, I think just in my zeal to get my application in there. There may have been a few oversights, but that is I don't believe it's an impression on who I am and the type of quality work that I can produce.
May I follow up?
Yes, thank you.
Thank you, ACJ. There's just one other concern that I also have with your application, and that is a lack of judgment, it seems, as to what is relevant and what not. I mean, the application is more than 1,000 pages long, and most of the attachments has nothing to do with what the Commission is interested in, specifically also when it relates to that question where your publications have been cited. You give us the whole report of the Law Commission, or the reviewed. Was it reviewed by someone? And there you refer to the Law Commission, and that was not a review, that was a reference. So yes, it is as if, one, that you didn't understand what was asked, and secondly, that you lack judgment.
Thank you for the question. I think it was an oversight. I referenced certain pages out of the law reform report, and it probably attached the entire report inadvertently. It wasn't the intention to make it prolix or overburden the reading of my application. I do apologize for that oversight. It was never intended to distract from the request and requirements.
Commissioner Dodo.
Yes, thank you very much. ACJ, good afternoon, Madam.
Good afternoon, Mr. Commissioner.
I've listened to you throughout the interview. You've apologized about 4 times, and in most instances, you indicate that sorry about that, it was a foresight. Now, my question is, do you think that you are fit and proper to be appointed as a judge at this stage? And why, if you think that you are fit and proper?
Thank you for the question. I believe that I do have the attributes to be a judge. There are many layers to becoming a judge. And in my view, those attributes also include your temperament. It includes your accountability. It includes diversity. It includes ability to do and perform and execute your functions. I think I have demonstrated that through various ways. I know that the application, after having been scrutinized, might have caused some concern, but I can assure you, if you look at the judgments that I've written and the work that I've produced, I have, over the period of the 38 weeks that I was serving on the High Court bench, delivered many written judgments in the region of 20 or more. In total, I've calculated, and I've gone through all of them quite meticulously, close unto about 60 written pieces of work that I have produced. I'm relentless. I work hard. I am invested. And regardless of those concerns that may have been highlighted, I think there are other things that could also be looked at in terms of determining whether or not I will be able to perform. And I believe I can and will. And I will give you that absolute assurance that whatever I am tasked to do will be done to the best of my ability.
Yes, just the last one, ACJ. I've looked at your profile, which is quite impressive, including your qualifications and what you have written, and the fact that some of your judgments have been reported. But at this stage, given what I see and what I hear, do you think that you are ready, no longer fit and proper? You are ready to ascend? Given these concerns and the anxiety that I have about what I've just painted to you, do you think that you are ready?
With
Commissioner Dodo, how different is that question from your earlier one?
It's okay. It's okay. It's okay.
Okay.
with
It was a
humility.
devil's advocate. It's okay.
Yeah, okay. Judge President Mlambo?
Thank you very much, Acting Chief Justice. Ms. Andrews, good afternoon.
Good afternoon, CJ.
No,
Oh, sorry, JP.
yeah.
Freudian slip. It wasn't meant to be.
Ms. Andrews,
Yes, JP.
I just want to follow up on the question the JP raised with you about the matter that he referred to. I just want to know whether you informed the parties before you had the matter or when you started the matter that you were related to one of the parties.
Thank you for the question, JP. First of all, the parties that were named wasn't related. There isn't on the papers. There is no name therein that says this is my cousin. None of the litigants was Dalen Mitchell. The parties were different named parties. The only reference that could have perhaps alerted me to a connection to a political undertone would have been the 8th respondent as the Beaufort West municipality. But I didn't even know that that was his constituency at the time. So I believe I was naive. Perhaps maybe I should have looked at it more carefully, but nothing on the paper suggested that this matter is something that I should have dealt with in a different way. The parties, before the matter commenced, I remember coming into chambers to greet. They came in very late. We were pressed for time. They'd barely come in. I asked them were they ready to proceed.
Ms.
There
Andrews,
was counsel
can I just stop you
yes.
there? I just wanted a simple answer.
So sorry.
Are you saying is it your cousin
That's right.
was not named,
Not named on the papers,
Right.
JP, at all.
but his counsel was named? The
But I
Beaufort
later
West.
learned that was his counsel. I wasn't even aware at the time that was part of his counsel. I believed that his counsel was in Tilburg, and I stopped following what he was doing. I really had no idea.
Okay. Had you known beforehand when the matters allocated to you, can you tell us what a responsible judicial officer would have done?
A responsible judicial officer, JP, would have recused him or herself. I do understand what the requirements are, what threshold needs to be met, the double reasonable test set out in the seminal judgment of SAFU, and I can assure the commissioners here that I did bring an impartial mind
Okay.
to bear.
My last question, Acting Chief Justice, how do you approach, as a judge, a situation where you have irreconcilable versions
in action proceedings?
Thank you for the question, JP. This would be where the Plascon-Evans rule would be applied, and it serves as a guideline to determine which party's version should prevail without the need to refer matter to oral evidence. So you would basically be able to deal with the matter, the arguments on the papers, but there is a proviso.
I said action
Oh,
proceedings.
the action proceedings. Oh, sorry, the action proceedings, when there are irreconcilable differences.
Versions, yeah.
Versions. In a matter, thank you for that. I just needed to recollect my thoughts. In some instances, you may have to grant absolution where you can't make a decision.
Thank you very much, Acting Chief Justice.
Thank you. What is a misdirection, Ms. Andrews, in the context of a judgment?
A misdirection, ACJ, would be where it has to be, first of all, it has to be a material misdirection that is startlingly or disturbingly or shockingly inappropriate, where the court may have misdirected in terms of a decision or coming to a decision. It could have been on a jurisdictional perspective, it could have been on a point of bias, and various other considerations, ACJ.
You are not helping me, Ms. Andrews.
Okay.
If I ask you what a misdirection is, and you say a misdirection is where you have misdirected yourself.
No. Where you've erred, where somebody has made an error by not applying the correct legal principles, or have maybe dealt with the matter and applied the wrong law or the wrong legal principles in a certain circumstances. So it could range, as I say, it could be a misdirection on jurisdiction, or it's just a wrong decision.
Commissioner JSC.
Actually, good afternoon.
Yes.
No, I'm following up from the questions by Judge President Mlambo.
Yes.
Your answer to his question, which is, in situation where there are irreconcilable versions in an action, your answer is that you must grant an absolution.
I said you could grant an absolution.
No, that's not
Yeah.
a question what
Yes.
could, but is what do you do? So it's either a question is that you grant an absolution, or you give us an answer of what you must do.
The parties make out their matter in their pleadings. Their pleadings must speak to, and it needs to be backed up with the evidence. And if the pleadings and the evidence do not meet, then
You must, I'm sure you want to, we don't want
Yes.
to be detailed on this. The question is simple. Evidence has been given, but the versions are irreconcilable. These are mutually
indestructible versions.
The question is, what do you do? Your answer is you grant absolution. That's what I want to follow up. Can I?
Yes. No, you don't always grant it. You can also just,
But what do you
you
do?
can dismiss the action.
Just because this version, the plaintiff saying, I gave you money, this one saying, you never gave me money. So your next step is to dismiss that action.
It doesn't always have to be that either. It depends. It's a very vague and broad question.
What is vague? This is straightforward. Plaintiff has given a version as a plaintiff, as a witness. Defendant gives a version. You are a judge, you must decide this matter.
You decided on a balance of probabilities.
How do you do that?
You weigh up the evidence and you see which version is more probable.
My point, just at the last point, is
I mean, when you give your answer, I just have to understand. Have you presided over a trial?
Yes, I have.
But you don't know the basic rule of dealing with evidence in a trial. Thank you.
Just a follow-up.
Thank you.
Just a follow-up.
One sec. Do you want to respond to that last part, Ms. Andrews, or not?
ACJ, I think it's just the nerves. I have dealt with many, many matters, and I think, in fairness, I would certainly consider those the matter before me. I will consider the legal principles. It goes just beyond just a very clear-cut answer in my view. It really depends, and for me, I would do the research and then come up with a just resolution in the end.
Okay, I'll take Commissioner Madonsela's question, and then I'll go to the commissioners on the virtual platform, and then we'll not take further questions from here. Okay, Commissioner Madonsela.
Thank you, Acting Chief Justice, and good evening. Good afternoon, ma'am.
Good afternoon, Commissioner.
Can I, just to assist you, can I ask you to go to book 1 and go to page 191. Paragraph 64. Can you see that paragraph?
Yes,
Why are you smiling?
because I remember. I think it was the nerves, and I thank you for that. I think that the judgment speaks of my ability to be able to discern and to give the correct answer, because the outcome was, I believe, correct. I do appreciate the assistance.
Thank you.
Thank you. Commissioners on the virtual platform, any questions?
Yes, please, Acting Chief Justice, it's Glynis.
Yes, please go ahead.
Thank you. Good afternoon, ma'am.
Good afternoon.
Could you tell me, in your view, what you think the most important attribute of a judge is?
The most important attributes of a judge, in my view, would be judicial integrity. Judicial integrity would...
No, that's fine. That's the answer. Thank you.
Thank you. Thank you.
Thank you, Acting Chief Justice.
Thank you. Nothing further from the virtual platform. I think we have...
Thank you.
Thank you. We've come to the end of this interview. Thank you once again, Ms. Andrews, for availing yourself, but you are now excused.
Thank you, Acting CJ, and thank you to the commissioners.
Thank you.